Welcome to the International Jurisdiction Academy channel. My name is Patrícia Abreu, and today we're going to discuss the jurisdictional immunities of the state case, decided by the International Court of Justice on February 3, 2012. The case was brought before ICJ by Germany in 2008, on the basis of a breach of international law obligation committed by Italy out of disrespect of Germany's internationally granted jurisdictional immunity before foreign courts. Firstly, Italy will have breached international law by not dismissing civil claims seeking compensation from Germany for personal injuries inflicted by the German hike at Italian territories during World War II. Also, by enforcing the decisions rendered by Greek courts against Germany on massacre claims also occurred during World War II. Secondly, it took measures of constraint against Germany's property situated near Lake Como, in order to guarantee the compensation that arose thereof. Before deciding the issues put forth before it, the court recalled the facts that originated the Italian and Greek civil claims. The Italian cases were based on the intention to receive from Germany individual full compensation for the imprisonment and forced labor of civilians and members of the Italian army who were denied any kind of compensation by Germany's laws and treaties on the matter, as could be seen from the cases concerning Mr. Ferrini, Mr. Mantelli, and Mr. Maieta. The Greek case were based on the full compensation recognized by Greek courts due by Germany to victims of the Stonewall Massacre, whose enforcement were denied by Greek and German courts as well as by the European Court of Human Rights. The ICJ stressed afterwards that the jurisdictional immunity, as recognized by both parties, is not a matter of committee, but a right ruled by international custom that grants sovereign states the right not to be brought up before foreign courts without its consent, with a corresponding international obligation for other states to observe it and give it effect. It also highlighted that the acts perpetrated by Germany in the context of World War II were considered a serious violation of international law of armed conflicts and thus internationally illegal. Germany's responsibility for those acts would nevertheless not be the object of the court's reasoning, but only the conflict on the definition of jurisdictional immunity extent, especially when it concerns acts committed by armed forces in the course of an armed conflict at the foreign territory. Germany considered those acts to be of jure impairing nature, while Italy considered that torts occasioning death, personal injury, or property damage at the foreign territory cannot bear said nature, particularly when those acts consider serious violation of jus cogens norms. Hence, Italy sought the dismissal of Germany's claims, firstly because it considered that jurisdictional immunity should not apply when it comes to injuries and life losses occurred at the foreign territory. Italy argued that Germany's immunity should also be dismissed on the fact that the acts committed by Germany's military force consisted of grave violation of international humanitarian law, and therefore of jus cogens. Besides that, giving effect to immunity will mean denying the victims any form of redress. The court then, initiating its observations on the party claims, stated that by the first Italian line of defense, it was not called to decide whether the commitment of torts would or not constitute a general exception to state immunity, but only whether acts committed by armed force in the course of an armed conflict at the foreign territory would fall into that exception rule. It noted as well that there was no treaty into force for both parties on the matter of state jurisdictional immunity, as Italy was part of none, which was the reason why the case could only be ruled by customary international law. Notwithstanding this, the provisions of the Article 11 of the European Convention on Jurisdictional Immunities and Article 12 of the United Nations Convention on Jurisdictional Immunities of the States served to the court as a window for the content of customary law on the matter. On that basis, the ICJ considered the acts performed by armed forces to not be an exception to jurisdictional immunity for torts committed at the foreign state territory. The same conclusion, in the court's opinion, could be drawn from the state practice regarding the national court's jurisprudence. Therefore, the ICJ concludes that customary international law continues to recognize, and I quote, immunity in the proceeding for torts allegedly committed on the territory of another state by its armed forces and other organs of states in the course of conducting an armed conflict. By such, Italy had no grounds to deny it to Germany. When it comes to Italy's second argument, that serious violation of human rights law and just causes norms were a material general exception to jurisdictional immunity of states, the ICJ observes that, when it comes to the vast majority of national courts' decisions, they do not consider serious violation of human rights law to be a general material exception to civil lawsuits. Neither is considered to exist an actual conflict between just causes norms and those customary laws granting jurisdictional immunity to foreign states, as those rules have different levels of applicability, being jurisdictional immunity rules of procedural nature, not bearing upon the lawfulness of the subject brought up to court, while just causes norms are of substantive nature. In order to support this reasoning, the court demonstrated that the law ruling a just cause case is the one into force at the time of the violation, and the one concerning jurisdictional immunity is that into force at the time of the proceedings. It also said that Italy's court decision was the only to have reason in order to recognize said non-existent conflict. The third and last Italian argument, that granting immunity would imply denying access to justice, also couldn't find acceptance by the ICJ. It was noted that customary law that grants jurisdictional immunity to foreign state is not subordinated to the existence of alternative ways to grant redress to the victims of any torts. Such condition could neither be found on communitarian, regional, or municipal laws. The court addressed then the question of whether the combination of the three previous Italian arguments would be sufficient to allow Italy to deny effectiveness to Germany's immunity of jurisdiction. Considering that none of those arguments could stand alone, the ICJ found that relying on the effectiveness of the jurisdictional immunity to an analysis of the weight of the material claim would disregard the very nature of state immunity. For these reasons, the court found that Italy had no grounds to deny recognition and effectiveness to Germany's jurisdictional immunity in the way it did. On the matter of the constraint of a German property to give enforcement to Greek decisions, the ICJ observed that immunity of state's property goes further than the jurisdictional immunity of the foreign state, as the former stands even when the latter does not, and a waiver on the former does not mean a waiver on the immunity of the enforcement, an argument that could only have a place when concerning properties that were not being used for governmental purpose. Italy thus violated Germany's immunity by granting exequatur to Greek decisions, as the exequatur itself meant the exercise of Italian jurisdiction of Germany. Therefore, the ICJ found that Italy breached international law by not granting Germany immunity of jurisdiction before its courts, thus engaging Italy's international responsibility. The ICJ then considered the most suitable reparation and condemnation of Italy to be the uplifting of all the constraint enforced against Germany's property and rendering destitute of enforcement all the decisions given by Italian courts out of disrespect of Germany's jurisdictional immunity. Worth of mention is the reasoning of Judge Cansado Trindades' dissenting opinion, who was the only judge to vote against all the Germany claims. He highlighted that states cannot waive inter se rights that belong only to individuals, and war crimes cannot be classified either as jure imperi nor jure gestione, but only as delicta imperi. Those as such could not be entitled the privilege of jurisdictional immunity. That should be exceptional. Additionally, upholding immunity in the given case constitute a bar to the realization of justice, which should prevail as being of a just caution's nature. The importance of the case to international law abides on the resolution, on judicial grounds, of a long-standing debate on the impossibility of denying recognition of states' jurisdictional immunity before national courts whenever the claimants seek redress for torts committed during wartime, and the impossibility of just causes as a substantive matter to be taken as general exception to jurisdictional immunity of foreign state, which is of a procedural character. On top of that, the ICJ's reasoning on the present case signalized the court's opinion on the matter of the characterization of universal civil jurisdiction as an international unlawful act. Nonetheless, it continues to be object of scholar attention, especially because the Italian Constitutional Court has found the provisions adopted by Italy to implement the ICJ's judgment contrary to Italian Constitution, rendering it out of enforcement in Italy. Thank you. Hope you enjoyed the case.